Let me help you avoid 3 common mistakes that delay closing when the seller inherited the property from someone who passed away. Number 1, not reviewing the most recent deed to the property. In Florida, if someone passes away with either only their name on the deed or with a co-owner but without proper language to pass their ownership along to the co-owner, then a court-supervised process called probate is required before the property can be sold. The purpose of probate is to gather the assets of the deceased person, pay their debts, and distribute their assets to their beneficiaries. Depending on the number of beneficiaries and the number of different assets, probate can be a time-consuming and costly process that proper planning can avoid entirely. If, on the other hand, the most recent deed shows the ownership interest as being held by husband and wife, or as joint tenants with rights of survivorship, or by trustees of a trust, then probate is not required and the typical closing timeline can be used. Number 2, assuming that having a last will saying who inherits the property avoids the probate process. Regardless of whether the last will is handwritten on a napkin or by an attorney in perfect compliance with the law, the wording on the deed will determine whether probate is required. It's always a good idea to have your wishes documented in a last will, especially if you have complicated family dynamics and you don't want the Florida statutes to decide who gets your assets after you pass away. And it can simplify the probate process. But if the deed is in the decedent's name alone, or without the proper language passing it to a co-owner, this court proceeding will be required before a sale can be completed. One of the ways to plan around this mistake is to update the deed to the property to either add a joint owner with survivorship rights or name your beneficiaries on a life estate deed. If the property is your primary residence, the Florida homestead laws may restrict who you can deed the property to or even devise it to under a last will. There can also be unintended property tax and income consequences when a new deed is recorded in the property records, so please consult a professional if you think this option may be right for you. And the third mistake that can delay closing is not funding a trust. A trust agreement that says who gets the property is just an expensive piece of paper unless the asset is also titled in the name of the trust. This is called funding the trust. A bank account statement or stock certificate can be updated to show the name of the trust, and with real estate, the deed should be updated to show the owner not as you individually, but you as trustee of your trust, the date the trust agreement was signed, and the powers you or the successor trustees after your passing have to sell the property. Even if your only asset is your home, your estate is not too small to plan for, and you may simply need an updated deed. If you've already inherited property and it's too late to plan around these mistakes, our office can help you navigate the probate process efficiently so you can stay as close to that initial closing timeline as possible. Text the word probate to 561-225-2676 to set up a time to speak with me.